of the flight and the fate that Dr. Besigye Kiza, who remains in a pre-trial detention in Luzera prisons, despite the Supreme ruling, which took place on 31st January 2025. The Supreme Court directed the executive to take immediate action, including amendment of the UPDF Act and the transfer of the civilian courts of all active cases involving civilians and the military court. However, to date, uncertainty prevails on the status of implementation of the directive of the Supreme Court. For the sake of clarity, I would like to pose the following questions to the Minister of Justice and Constitutional Affairs, to the Attorney General, and the Minister of Internal Affairs. 1, have the legal advisors to government rendered appropriate advice on the continued pre-trial detention of an ailing Dr. Besigye? 2, what is the legal basis for the continued detention of Dr. Besigye in Luzera? 3, under what instrument does Uganda Prison Service continue to hold Dr. Besigye? 4, what steps have you taken to comply with the Supreme Court directive? 5, how long will we take to conclude the transfer of all active cases involving civilians from the General Court Martial to the civilian courts? 6, what sustainable action have been taken to address the concerns surrounding the health of Dr. Besigye? As a House of Representatives, we are a voice of the voiceless. We are elected to speak for those people out there who cannot be in this house. So if we cannot do that, then we are not representing our people. The continued detention of unwell suspected sets a dangerous precedence that may be applied to any one of us. Injustice to anyone is injustice to everybody. Today it is happening to Dr. Besigye, tomorrow it will happen to any of us. There is need to explore other appropriate modalities of confinement, if necessary, than keeping the ailing suspect in unfavorable conditions that may potentially be fatal. I am aware there are legal regimes that govern the pre-trial detention on treatment of suspects with peculiar circumstances, notably the Constitution of the Republic of Uganda, 1995, and the Trial on Indictment Act, 1971. Honorable members, I'm aware that the presiding officer previously.
This morning, I had a conversation with the Commissioner General of the Uganda Prison Service to find out the current situation of Colonel Kiza Besigye. He told me the following. As of today, Colonel Kiza Besigye has been on hunger strike for 6 days. This is his seventh day. He is only taking water. He's not eating any food. The Commissioner General informed me that because of the hunger strike, his health has deteriorated, and therefore he had to be evacuated to a hospital. His personal doctor took charge of the evacuation in the presence of Colonel Besigye's sister, Dr. Olive Kobusinje. It's not appropriate for me to report details of what was found. This is a part of the doctor-patient confidentiality. But the Commissioner General said definitely his health condition is alarming. Under all the laws of Uganda, any person, especially those who are having health issues, are entitled to treatment. And in this case, the prison authorities were able to take him to the hospital. Comprehensive tests were carried out, and the doctors are managing him. The Commissioner General also informed me that Colonel Kiza Besigye has continued and continues with the hunger strike. And that means, of course, that any medical response will not have a major impact. He will not improve because of the hunger strike. Now, concerning your other question about the advice, the laws, what steps we have taken, how long it will take to transfer the files, I wish to report the following.
Honorable Minister, just on hunger strike. He's not on hunger strike because he loves to be on hunger strike. He's on hunger strike because he believes he's unfairly treated. He's on unfair trial.
Madam Speaker, hunger strike is a form of protest, and I accept what you have stated. He is protesting through hunger strike. All through history, prisoners who feel that they are being unjustly incarcerated have resorted to hunger strike. So, but it is not my purpose to go into detail why he's on hunger strike. I simply reported his condition, and we admit that it is alarming. Now, permit me, Madam Speaker, to respond to...
And as a legal advisor to government, after knowing that his condition, his situation is alarming, what advice have you given government to that effect?
Madam Speaker, that is what I'm coming to, because you gave me a set of questions, and I would like us to go through the chronology of what we have done. The judgment was delivered on 31st January, which was a Friday. Immediately on Monday, Madam Speaker, the Attorney General wrote to the Ministry of Defense and the DPP. That is the very next working day after the judgment. The Attorney General wrote, informing them that the cases should now be transferred. On the 3rd, the very same day, the Attorney General also wrote to the Chief Justice asking the Chief Justice to appoint a judicial officer to be in charge of liaison concerning the transfer, who should liaise between all the actors. That is the first working day after the judgment. On the 4th of February, the Chief Justice wrote back appointing the principal judge as the liaison officer. That is the second working day after the judgment. On the 6th of February, the Attorney General's chambers forwarded the letter of the Chief Justice to the Ministry of Defense and Veterans Affairs and to the DPP. Around that time, Madam Speaker, we were here and I came to the floor and stated that it is the duty of Colonel Besigye's lawyers and the lawyers of all those who are in the court-martial to extract a decree that is part of their responsibility to their client. This decree only arrived on the 13th of February, almost 2 weeks after the judgment. That is when we received the draft decree. Unfortunately, Madam Speaker, the draft decree had errors. Some of the errors were as obvious as wrong names, for instance. On the 14th of February, that is last Friday, the Attorney General's chambers corrected...
Do you have a copy of the decree which was extracted?
Madam Speaker, the errors were corrected and the corrected decree was sent to the lawyers of Colonel Besigye. We have not yet received the corrected decree. If we have received it as of now, we corrected it from the Ministry of Justice. We are concerned by the slow pace of Colonel Besigye's lawyers. I have stated the chronology. You cannot take 2 weeks. If really you are concerned about the condition of your client, rather than the politics surrounding that, they should have acted as fast as Attorney General's chambers.
Honorable Norbert Mao, help us to help you. That's why I was asking you, do you have the wrong copy of the decree? So that we shall not take the blame to who? To the lawyers.
Madam Speaker, I have here on my phone, which I can forward, a letter dated February 14th, sending back the corrected decree. I can forward it.
That was sending back. When did it come?
The decree came on the 13th. The very next day, it was sent back. That's how fast we are, Madam Speaker. We have done our job, but those who have chosen to politic rather than take responsibility for the fate of their client are now playing victim. That is unfair, Madam Speaker.
Right, Honorable Speaker.
Honorable Mao, the bureaucracy in addressing the directive of the Supreme Court should not be a ground of delaying in dispensation of this for somebody to get justice. Okay, if they delayed it to bring that, have you brought the amendment that they told you to bring? Or is it we, the members of parliament, who have delayed? Huh? And must you continue holding the suspects outside the law just because of the bureaucracy? Because they are not tried, they are on a pre-trial. They are not on remand.
Madam Speaker, I am on record, and on the day that the new law year was opened, I addressed the members of the judiciary and I appealed to them to prioritize matters of the liberty of citizens.
We're going to suspend the House. Suspend the House for 10 minutes, and then we'll come and report. If the 10 minutes is not enough, we shall still communicate. No one